Slides here that I've prepared on some of the main changes that have taken place to TUPE. I do just want to start by saying that these changes have only come in on the 31st of January this year, and some are not anticipated to kick in until July. So it takes a lot of time for change to embed to any legislation. So even the courts haven't had time to test any of this yet. So it is really, really new. I can't rely on any precedent, and it's very, very difficult to prejudge what outcomes might be in cases around new TUPE. So I just want to make you aware of that. Decisions are probably for a while going to be made on very much a case-by-case basis. And as employment law is not an exact science in any case, it's going to be very, very difficult to be precise about some of your more specific concerns at this stage. I've got a few slides put together that copies will be available at the end of the presentation, and I've also got a few of the bits and pieces of information around TUPE, but they are more specifically geared around TUPE and not around your organisational structure or anything that is going on with your own roles. I'm going to start by just walking you through some of the main changes that are going to be happening to TUPE. There are 7 main changes. The ones that I think, some of them are quite straightforward, some of them are quite subtle, and some of them are majorly worrying. Majorly worrying to me from a legislative perspective are issues around changing contractual terms and conditions, varying terms and conditions. Also issues around dismissals, and employers now widen scope to potentially alter the content of collective agreements. So, starting with the first change, this is a fairly straightforward one, but the test to remember here is around work that must be fundamentally the same. Very much on the same basis that we have the debate about reasonableness. What is reasonable? What is fundamentally the same? Because quite often in scenarios around TUPE, an employer's perception of fundamentally the same and an employee's perception of it can have a bit of a disjoint, and that's something that is potentially going to be a bit of a bust-up in certain organisational structures, actually determining what constitutes fundamentally the same. The second change is one of the first grislies for me, really, is the employer's widened scope, if you like, to amend terms and conditions. And we really don't know at this stage how far-reaching this is going to be. It's really just a wait-and-see situation. Removing things like the ETO. Is everyone familiar with an ETO reason? It might be an idea to just explain that. An employer might be changing making workplace changes because of issues around profit, issues around productivity, and issues around output. So anything with a pound sign in front of it is obviously a concern for any employer. Maybe they want to technologise a particular area of an industry or organisation, and we probably don't need to outline what that entails, or an organisational reason. So that could mean a restructure, a reorganisation, a delayering, a streamlining, harmonising, mutualising, all of those words that tend to mean one and the same thing. So removing that could be problematic. There's also potentially an issue around the employer and employee failing to agree. Obviously these changes are outlined as being able to take place if both parties agree. In reality, we often get a situation where both parties do not agree. We have a fail to agree situation, which effectively is a bit of a stalemate situation, in which case reps, unions, organisational structures need to be a bit more robust, maybe sharper and smarter in actually dealing with the process around agreeing changes. Changes around dismissals. This is a bit of an issue. It's quite a complex issue around automatically unfair dismissal. If the reason for dismissal is the transfer itself, you've been dismissed or a member has been dismissed in relation to the transfer itself, it would still be automatically unfair, as it has been in the past. But it's no longer automatically unfair if the reason is connected to the transfer. And the very subtle disjoint between that is the dismissal itself and something that is linked to it. And it's very, very difficult to make that delineation, very, very difficult to pin that down, but it's worth noting that there is a sneaky little change there which could potentially be quite problematic down the line. Again, if the employer can establish there was an ETO reason, it would not be automatically unfair. But it's important to remember that the tests of general fairness do apply, that they're not just wiped out because of this change. So an employer would still have to satisfy the criteria to say that they'd made a fair dismissal. Okay, we now have the workplace factor, which is also moved into the scope of changes that happened after January this year. Prior to that, transferring employees to another location is difficult because that would be automatically unfair. That is the change here. That is the crux of this change, is that moving employees to another workplace location won't be automatically unfair under these changes. They may still be unfair. Collective agreements then, another quite an important, quite a significant change, basically gives employers the right to make changes to the content of collective agreements a year after the transfer has actually taken place. Again, applying to any transfers that have taken place after that cut-off point. The contract must, however, be no less favourable. So a bit like the test of reasonableness, the test of fundamentally the same. There's going to be the question of how you quantify something as being no less favourable. Is the employee going to be put at a detriment because of anything that has been put in place as a result of these changes? So again, this isn't going to be something that's going to have a guillotine effect. It's going to be something that is made, a change that is made quite subtly and perhaps over a period of time. There are a series of things we need to consider around employers being bound by the changes, but unfortunately, again, the courts have yet to establish the line in the sand in terms of deciding the extent to which an employer can actually change those terms and conditions. So again, it is very much a wait-and-see situation. A bit more on collective agreements. The changes specify when terms that are in the collective agreements can be changed in transfer situations. So the three main things to think about here, I think, are how far can an employer extend this provision? How far can they go? What is their remit? How might they bring these changes around? How can they bring them about? And what sort of changes might your employer be seeking to make? What sort of changes might they be looking to implement as part of your collective agreements? What do they want to change about the terms that you have as transferring employees? And that is really quite crucial for you to be thinking about. Obviously, it only covers the part of an employee's terms and conditions that are covered by a collective agreement. Other changes would be standard, subject to standard TUPE, and that is the TUPE that we refer to as TUPE 2006, the ones that were in place prior to these changes. I'm not going to spend too much time on redundancy, but obviously it is an issue in conjunction with TUPE. The consultation can begin for transfer if both employers agree, but quite often the time taken for employers and affected parties to have that agreement process, the clock is ticking. So it's important to get something in place, even if in the sense of a potential contingency, if you have a feeling that there might be some level of disagreement on either side. Changes that allow for redundancy post-transfer to begin before and continue after, and that's something that quite often gets missed. Things get lost in the ether. The set of changes have been agreed and then they're not followed through, or no one knows what happened to them and no one follows them up, and there can be a lot of confusion at that stage. So I think that's quite critical for you to think about as well, is keeping an eye on an audit trailing all of those changes both before and after, and making sure that employers are not selecting for redundancy before that transfer takes place. And the normal rules apply in terms of the law affecting redundancies, and the selection criteria basically around the consistency of that criteria. New TUPE is not an excuse for those redundancy regulations and processes to be changed or amended up. That is not an agency for that to happen. Employers are obliged to consult on TUPE both before and after, and those types of consultation can run concurrently. Now, I imagine there will be some questions about timeframes and when consultation needs to begin. In terms of redundancy consultation, the only obligation on an employer is to ensure that consultation begins in good time. Now, again, what does in good time actually mean? It's a bit like the reasonable debate. What is reasonable? What is less favourable? What is in good time? Okay, the next change, employee liability information. You may hear this referred to as, just get bandied around as ELI. This is more usually information that the parties need as part of this consultation procedure. So this is the identity of the transferring employees, their age, their employment particulars, any grievance and disciplinary records, any details of any claims that are outstanding against the outgoing employer as well, and details obviously of any relevant collective agreements. So all of that information that was a stipulation in 2006 TUPE, it stays, it remains, it doesn't change. The only change is the time frame. This must now be provided no less than 28 days before, rather than 14 as previously. So a slight time frame change, but the standard and quality of information, the amount of information, does remain the same. Changes around information and consultation. A lot of this is really quite oblique. However, before January this year, the regulations required both parties to arrange for election of reps if there's no recognised trade union. I'm not sure if that would apply here, because we're looking at an organisation as a whole, not in the sense of a micro business, which would be a part of a business that just had less than 10 employees. So it's worth just noting that this is the one change that hasn't actually kicked in yet, but I doubt if it's applicable, but I mention it just for the sake of outlining all the changes. I've mentioned a few things to watch out for. There are many, many more, and we're finding out as we look at scenarios where TUPE might potentially apply that there are some grizzlies that we haven't actually taken account of. I think we need to focus quite extensively on ETO reasons. Employers do tend to use these as a catch-all, I was going to say excuse, I'm not sure if that's the right word, justification for making certain changes. Well, it's an ETO, it's an economic reason, it's to do with outputs and productivity, therefore we can do it. It's a really good idea to keep a very close eye on what actually constitutes an ETO reason. It cannot be used just to reduce labour costs or to streamline or to harmonise terms and conditions. If anyone feels that they are out of their depth with that and they're really not sure with it, then I would prefer anyone to direct any specific inquiries to legal section. We talked very briefly about changes in workplace location and that link to potential for dismissals. This is quite common in transfer situations. Changes to TUPE now state that moves do now constitute a fair reason for dismissal, and it is worth just looking at what is actually fair. How, if an employee has been asked to relocate and travel 300 miles a day, is that going to be fair? What is that cut-off point? What is no less favourable? And is the employee going to be put at a substantial detriment because of that? Those are the things to be looking for excuse me, when we mention ETO and workplace location changes. We have mentioned contract variation issues, changing terms and conditions. That 1 year period is one to look out for. Sometimes there's the negotiation before the transfer, that is ongoing afterwards. It's a good idea to be savvy about dates from the off with this. If the employees are ratcheting up to making some changes, what is that 1 year cut-off point? Is there something that you can do in terms of challenging the timeframes on that? Because if it is a situation that you know employers want to make changes to terms and conditions, are they just sitting there waiting for that 12-month period to be up so that they can implement them? It is one to look out for. Employers seeking to vary terms and conditions, yes, they may still face a claim of constructive dismissal. It would not be a good idea to object to a transfer just in principle or for the sake of it, but you would still have a case to object to that transfer if it meant that you would be subjected to a substantial change in your job and that it would put you at a detriment. In any constructive dismissal claim, that would be the criteria to meet. It would be that it was no longer tenable or practical to continue your role because of something that had changed. That applies in TUPE, it applies more generally in employment law general terms as well. So your ability to resort to constructive dismissal claim does remain the same in a TUPE situation. So while it would not be a good idea to just object and jeopardise your employment status, it is a good idea to keep an eye on, well, is my contract of employment being undermined? I've mentioned a resource here. The ACAS resource is a very good resource more generally, just for looking at more in-depth explanation of TUPE, and they have produced recently quite a useful, I haven't got any copies of this, but it is on that website, the changes to TUPE, because quite often when you Google something or you just put in TUPE onto a general search engine, it will just bring up the 2006 regulations. A lot of those websites haven't been updated to reflect the changes that have taken place to TUPE, so do watch out for that. The relevance, the newness of information is something to look out for as well. I've mentioned also not getting sidetracked by the details of a formal written contract. So looking at a contract before the transfer and looking at it after. I'm trying to get people to focus on whether there actually is a service provision change. Is what's happened here actually a service provision change? And whether the employees are assigned to an organised grouping of employees. So focusing on the status of employees at the time of that transfer is more crucial. Don't get bogged down in the nitty-gritty of the actual contractual terms. Focus on the status of the employee and whether they are actually an affected employee and whether they are in scope for that transfer. I've tried to anticipate, based on some questions that I've received, around what are the changes going to mean? What if this happens? What if that happens? The ones that I thought people might be faced with that have been brought to my attention are, well, what if the identity of the client changes? What sort of issues might there be around that? Well, basically the client has to be known. You have to be working for someone or anticipate working for an organisation that you actually know. You can't be expected to work with a blindfold on, in effect. What if only part of a business is transferred? Well, there can still be a TUPE transfer as long as there is an organised group of assigned workers. So that is crucial to look out for. Are the people who are transferring, even if it is only part of the business, do they belong to that organised and assigned group of workers and the transferring part of the business? What if the business is outsourced to more than one provider? This is suggested in some areas. Well, TUPE would still apply. Pretty much a follow-on from the second point. Part of the business, it might be outsourced to more than one provider. The same new TUPE change provisions would apply. Does TUPE extend outside the UK? Yes, it does, as long as the location of that business is grounded in the UK. Employees cannot contract out of TUPE. It's a bit like the objection scenario. There would have to be, the TUPE would be absolute. It would just apply automatically. It wouldn't be something that you would have an option not to have a buy-in to. It would automatically transfer. If employees are on sick or statutory or contractual leave, that would be irrelevant. They would transfer anyway, even if they weren't actually physically at work at the time of that transfer. Temporarily assigned employees, a little bit of a grey area. Missed out workplace reorganisation, I'll come back to it. A temporarily assigned employee would generally not transfer, but a practice that we have seen emerging in some organisations, I'll be very careful about naming them, but there is a practice currently ongoing where employees are being given effectively a paper promotion. They're being given a managerial job title with no extra benefits, but that then makes it very difficult for them to claim that they've been put at a detriment. So they've been offered, if you like, an enhanced status within their organisation, so that it becomes very difficult and closes off that opportunity for them to then argue a case for constructive dismissal, or that they've been put at a significant disadvantage because of the TUPE process. And it's a really, really cute way of getting around this particular provision. So if there is a group of temporarily assigned workers, it may be that they are put in that bank of workers that are offered an enhanced working provisional role, in which case they would be placed into the transfer situation. So that is a practice to look out for. I mean, these changes are new, but I've seen this happen in 2 organisations already, and that's just since January. Workforce reorganisation. Quite often there are reorganisations in the run-up to a 2P situation. Quite often that is done so that employees can remain with an employer, or there may be an unspoken selection criteria that an employer is trying to impose. There's not really very much we can do about workforce reorganisation apart from ensure that the normal provision and the normal regulations, rules and procedures are adhered to. We've talked about objecting to a transfer. Not a good idea unless it is to do with there being some sort of detriment that you might suffer as an employee, or the ability to claim constructive dismissal. Union recognition does transfer. The only issue around that would be where there is no union recognition in the area to which you are transferring, but your normal recruitment, your abilities, your opportunity to get people involved and to recruit reps, to co-opt people onto negotiations around the 2P post-transfer would still be the same as they were prior to January. There would still be the opportunity to recruit and to look at making union recognition and membership more robust. What the 2P would not be able to do would be to act as an agency for derecognition, which has been suggested. That would not be an agency for 2P to use. Pensions, obviously the provision around pensions is very difficult to be precise about in one line, and we also have the issue of auto-enrolment as well. So pensions, I would actually direct you to the ACAS guidelines on pensions, and also you'll have your own organisational structure around pensions, which I'm not party to, so I wouldn't be able to give any pointers on that. That pretty much brings me to the end. I do have some resources which I think I mentioned will be given out at the end, which basically just outline the very, very bare bones of the 2P changes. There is also, I just wanted to draw your attention to this little booklet. I don't know if anyone has it or if anyone was intending to get their hands on it. Please don't bother, it's woefully out of date and I haven't had time to update it yet. So it is still relating to 2006. So we do have a resource on it that is prospect specific, but it hasn't been updated yet. So just to make you aware of that, if you see it floating around and think that might be useful, it isn't, because it is out of date. But we will be updating, I will be updating it, and it will be available shortly.